So it's 17:30. Good evening, everybody. Welcome to Glasgow, to virtual Glasgow, to the digital equivalent of the Humanities Lecture Theatre, which you have seen on the holding slide. This is where we hold our public lectures in a normal year. I'm Martin Kretschmer, I'm the director of the Create Center, and I will be your chair for tonight. So it's very possible that something will go wrong. It's the first time we experiment with this precise format, and we haven't had a chance really to practice some of the interchanges with the panelists, but I will take a risk really to introduce you to the panelists. So we are here really for a public lecture with experimental context, find different ways to converse, to deliberate, which in some ways is the topic of tonight's lecture. So it's some form of deliberation exercise we are engaging in. And the topic of tonight's lecture by Professors Lee Edwards and Giles Moss is improving deliberation, improving copyright, reflecting on the public voice in copyright consultations. Lee Edwards and Giles Moss have developed an innovative and challenging perspective on copyright policymaking, drawing on theories of deliberation, and their disciplinary anchor is, quite unfamiliar to lawyers, and I see many of us in the audience. So the perspective for media and communications, I think, is important to understand how consultations take place at the moment and how they might be improved. So before I hand over to the pre-talk by Olaf Vogel, I would like to introduce the distinguished panel of discussants, Ian Hargreaves, Aline Iramina, and Martin Senftleben. So just to show you their faces, may I ask Ian just to speak? You should automatically be switched on. And maybe tell us what your previous involvement with copyright policymaking and with public consultations has been. Ian Hargreaves.
Change that.
Good evening. It works. I can see you. Everything is as it should be.
Good, thank you. Yes, my my career as an expert in copyright began abruptly and was entirely confined to the work that I was asked to do by the Cameron Clegg government on reviewing intellectual property with a report that appeared in 2011. It was like all engagements on this subject, controversial, and its findings were agreed by the government, both in general and in some detail. But there were many problematic fences that I encountered, that the review encountered as it tried to get round the course and deliver its message. And I'm sure we'll talk more about that later. But that's my credential for being in virtual Glasgow this evening.
Thank you, Ian. So now it's Aline Iramina, who is a civil servant in the federal government of Brazil and currently on leave. Aline, do you want to say a few words?
Sure. Can you all hear me? Good evening, everyone. Well, I'm here today because I have been working with copyright regulation for more than 5 years now in Brazil's federal government. I actually participate directly in organizing the last 3 public consultations we organized within Brazil's Copyright Office. So I think I have some experience about the difficulties that we face when conducting this kind of consultation. So I hope I can contribute to the discussion.
Thank you, Aline. And now to Martin Senftleben from Amsterdam.
Yeah, thank you so much. Well, it's a pleasure to be here. I think it's a very important point that we are discussing this evening. My personal involvement is particularly from an academic perspective. I've been active in two previous reform debates at EU level. This was the trademark law debate, trademark law reform, and more recently the copyright reform. And well, I had a feeling that in academic circles, there was quite broad and shared concern about some of the proposals on the table, but it needed some extra step to really channel this and prepare something that would be heard also at the level of policy making in Brussels. So I was involved together with colleagues in a small drafting team, trying to put in writing on just a couple of pages the main points of concern and the recommendation that we would have for better policy making. And then we circulated this, and we got quite a lot of support in the sense of colleagues also joining the initiative and signing. And then this, I think, made it easier to really get through and get a message across. So that's a bit of my personal involvement, and I also have followed now, after the copyright reform has been completed, the developments on the ground, how this impacts implementation. I can give also an example with regard to the practical impact. So more about that later. Thanks.
Lovely, thank you. So, in the order of play tonight, next is Ulla Furgal, Dr. Ulla Furgal, who is a postdoctoral researcher in Create, and she's the editor of a resource on the implementation of the Copyright in the Digital Single Market Directive. And we thought it would be a good idea to put some meat on the bones, as the Brits like to say, illustrate in some ways a process of live consultation, which is embedded in this 2-year process of implementing a very controversial piece of European legislation. So, Ulla, would you want to take over?
Yes, Martin, thank you very much. Thank you. Hello and welcome everyone to our virtual Glasgow. Thank you for joining us. Today my role is to warm you up a bit and to give you, to introduce you to our resource page that Create is building for a couple of months now, that we officially launched in May 2020, that deals with the implementation of the directive on copyright in a digital single market. So as Martin mentioned, the directive is a quite controversial piece of legislation and quite complex piece of legislation that has been adopted in April 2019, following months, if not years, of debates that on occasions were hanging by the thread. The adoption didn't attract a vote of all the member states in the Council of the European Union. It was already, we already have an action for annulment of certain provisions of the directive in front of the European Court of Justice. We also had public protesting this directive, both online and offline, going on the streets. So it is a quite controversial piece of legislation. However, the adoption of the directive in April 2019 didn't really finish the process of modernization of copyright law, didn't finish all the controversies, because now the directive needs to become a part of law of all the European member states, and this needs to happen by June 2021. So what our resource that you can now see on the screen is doing is actually tracking this implementation process. So the ambition of this page, of this resource, is to build a comprehensive and independent database of information on transposition process, so that anyone who is interested in this process can have an overview of what is happening in the member states, what are the options being considered, and what are the most controversial issues or problematic issues in the implementation. So the implementation is important to monitor, first because this is a controversial piece, but also because member states are left with considerable freedoms in implementing this directive, and this freedom concerns the most contentious issues as Article 17 and intermediary liability, Article 15 and the press publisher's right, as well as the regulation concerning authors and contracts. So the main part of the resource concerns the implementation in particular member states, and the gateway to see our entries about how the transposition is ongoing in particular member states is just in front of you. So it is a map feature where basically you can hover over a particular country, see how many entries it is there, and when you click on, you're basically taken to an entry of this particular country. So as you see, for example, now we have Germany in front of us. We're mainly, when we are providing information, we are trying to link to the source of information where we got this information from every time. So this is more of a database when you can search for original resources as well. And most of those websites, as you can see, are actually websites of ministries that are responsible of the intellectual property offices, working groups that are responsible for implementation in a particular member state. So as the map shows, most of the member states already started the implementation process, and the word already is not particularly appropriate here because the implementation process is ongoing for nearly a year and a half, I think. So most of member states started, but not many of them are actually advanced in this process. We only have 2 member states that implemented some articles, only 6 draft bills on a table. At least those are bills that are publicly accessible. Rest of the countries is still quite at the beginning of the consultation process. And consultations on the national level, it's something that is ongoing or it's closed in those countries. And it usually involves open calls for written submissions to particular consultation documents, stakeholder meetings, or establishment of working groups of some sort. So this is the main part of the page. As you can see, there is quite a content in here if you're interested in monitoring the implementation process. But apart from that, we also wanted to provide a broader context for the implementation process. And in here you can see such sections as academic opinions. So we basically try to bring together interventions and opinions of academics who analyze the implementation's options, providing some choices to policymakers. So there are both academic articles, as well as you see open letters by copyright associations, as well as the blog entries. On top of that, we are also monitoring the stakeholder dialogue that has been organized by the European Commission on implementation guidelines for Article 17. And we are also trying to monitor what stakeholders are doing. So in this section, you can find the interventional stakeholders on the European level. If you're interested, if we found some stakeholders intervention only concerning particular country, you can find it in the country section. And last but not least, we are also trying to provide a legal context for what is happening. So courtesy of Professor Alexander Buchert, you can here in this part, you can basically explore the directives where articles and recitals were grouped together. So it's quite a convenient resource. You can also consult parliamentary questions that were asked, as well as the case law of the Court of Justice, which we see as relevant for the implementation process, including the pending challenge brought by the Republic of Poland for annulment of certain parts of Article 17. And this is where I will leave the floor. I think. Okay.
So it is now time to hand over to our public lecturers, Lee Edwards and Giles Moss. After that, the Q&A function will be explained in a little bit more detail. But if during the lecture already certain questions arise, you're free to post them into Q&A. We have no chat function in this webinar. Okay, so I give the virtual floor to Professor Lee Edwards from the LSE and Professor Giles Moss from Leeds.
Thank you very much, Martin. And before we start, we'd like to express our thanks to Create and to you in particular, Martin, for inviting us here today and for organising the event. Create has offered invaluable support to our research over recent years, and it's a real honour for us to be able to contribute to the public lecture series. In the recent work we've done, we've also benefited from funding from the AHRC, now part of the UKRI, and in our most recent study from support from the Intellectual Property Office and Ofcom, and we're also extremely grateful to them. And we're really delighted to have the opportunity to speak to you all today. I'm just going to share my screen, and we'll just kind of have a few slides to accompany the talk. So as a bit of background, our work is underpinned by the principle and belief that copyright policy is a matter of public interest. And as such, it should be a subject of public discussion and debate so that the eventual implementation of copyright is one that attracts a general level of agreement among all affected parties. It's not necessarily a controversial view, and you would think that this would lead to efforts to engage the public in discussions about copyright law and policy, but this isn't generally the case. Despite being affected by copyright in their everyday lives, the public can lack understanding of it and opportunities to debate it. And while there have been user-directed campaigns aimed at shaping consumer behaviour, there tends to be a lack of public debate about copyright as a policy issue. And this neglect is echoed in academic research. Little work has delved further into public opinions about copyright, explored how they might be formed, and considered what might happen when members of the public are given a broader range of information about copyright from which to form their opinions. And this is the gap in knowledge that our research has tried to address. We've attempted to challenge the idea that copyright policy is too complex, too boring, or too abstract for the public to be interested in by running deliberative events about copyright with diverse groups of citizens. And our findings suggest that if members of the public are given enough information and time to learn about the topic, they have plenty of opinions and insights to share with policymakers. So, for example, at the event that we held in November 2016, oh, my slide has disappeared. Hang on, let me just go back to the slide. Okay, 1 second and I'll go back to the screen share. I'm really glad that Martin previewed that things might go wrong. So at the event we held in November 2016, where 88 members of the public came together over a weekend to discuss copyright policy, we found that they drew on a wide range of evidence from personal experience, from media stories, and from popular culture, so knowledge about copyright issues in music and gaming, for example, to articulate and justify their perspectives of copyright policy and practice. They were a critical audience. Glib justifications of copyright did not convince them, and their own discussions of cases were complex and nuanced. Moreover, they wanted to engage with different voices, including stakeholders they might not agree with. And one weakness of this event was that we were not able to include corporate and creator voices in the discussion. Nonetheless, our findings showed that after a weekend of reflective and informed deliberation, our participants' perspectives favoured copyright as a means of supporting the circulation of creative work, justified by civic interests and priorities. While the market was taken as an inevitable reality of modern life, its ability to balance the conflicting interests of corporates, creators, and users was questioned in their discussions. Our participants wanted lawmakers to accommodate and protect the public interest first and foremost, rather than being a tool that only resource-rich companies and individuals could use. So clearly this research showed the public's capacity to engage effectively and in an informed way in discussions about copyright, but it still left a key question unanswered. How might the public voice be included more effectively in consultations and the policy-making process? And this led to our second and more recent study on copyright consultations that Giles is going to talk about.
Thank you, Lee. Our recent study was a stakeholder-driven, impact-orientated project where we worked with stakeholders to consider how copyright consultations could be improved. It built on the previous work that Lee has described and the question of how to include the public more effectively in consultation, but it expanded our focus to consider the views and experiences of a wider range of stakeholders who participate in consultations and the officials who run them. So really, this second project was about exploring how consultations could be improved based on the experiences of those who participate in them, as well as investigating ways in which the public might be included more effectively. And it was an impact-oriented project in the sense that we wanted to generate insights and recommendations that could be used by those people leading the design and implementation of copyright consultations. The project had 3 parts. Began with a series of qualitative interviews. It then had a 1-day workshop, and it led to the development of a new framework of consultation based on the results, which we then presented to the IPO. Our participants comprised 6 people with experience of running consultations, 28 stakeholders who participate in consultations, and 10 members of the public. The stakeholders were from a range of sectors, including educational institutions, civil society, creative industries and producers and collecting societies. And our members of the public had all attended the previous weekend event that Lee mentioned, and so had some knowledge about copyright already. They also had some experience of consultations, whether it's community consultations, NHS consultations, or market research participation. For the workshop, not all participants were able to participate, and not all the people who participated in the initial interviews, but the final group included officials with experience of running consultations, as well as stakeholders from across a range of sectors. 28 participants attended in total. Many of the improvements our participants suggested were about the overall structure and conduct of consultations. But in suggesting these fundamental changes, they were also proposing a framework for consultation where the public would feel both more comfortable participating and more welcome to participate. Before exploring the idea of how to change consultations, we asked participants to describe the context and the areas where they felt consultations could improve. Many of the points they made echo previous research and media policy making more generally, but they were coloured by the specific context of copyright. One generally agreed upon point was that consultations tend to reflect the polarised landscape of copyright, where participants hold strongly opposed views. There is seemingly little middle ground and little dialogue between the parties. Consultations, for all the discourse they engender, do not always facilitate meaningful dialogue between stakeholders. Moreover, the public tend to be largely absent. A second generally agreed upon point was that copyright consultations were vulnerable to power dynamics. For example, those organisations with the resources, relationships and cultural capital to navigate consultations and provide the right kind of contributions were perceived to be most readily consulted, the most vocal, and or easier to engage with on complex topics. Those organisations that could speak the right kind of discourse that characterises a dominant view were perceived to be more useful or found consultations easier to respond to. Thirdly, consultations are highly specialised arenas and of course can be exclusive places. Civic actors, creative industry workers and the public may all find them more difficult to navigate than large corporations. Moreover, consultations are also characterised by informal as well as formal engagements, where informal engagement is less open to a wide range of participants, but can often be as powerful, if not more so, than formal processes. Fourthly, the participants tended to agree that the question of including the public in consultations was important. The public voice was largely absent, and this wasn't a good thing, because consultation should engage with all those affected by an issue, and copyright was recognised as an issue that was relevant to everyone. At the same time, ensuring participants are included does not necessarily equate to influence in contexts where outcomes can sometimes be predetermined, or where consultation is obviously just one part of a broader political process with decision-making power resting elsewhere. Finally, and after all these considerations, the more fundamental challenge of how to engage such a dispersed, disparate and broad group as the general public was a complex and perhaps even unanswerable question. They were not specialists, they're not versed in consultation language or context, They might submit poorly evidenced opinion which do not meet the standards set out for consultations and/or which are hard to incorporate into recommendations or proposals for policy change. These kinds of specific questions were underpinned by much bigger implicit questions about where can the public add value and what kind of value can the public bring to consultations. Arguably, the relative lack of independent research, understanding the public's view of copyright, and the lack of representatives representing their voice and the former consumer focus not being replaced exacerbates the difficulty of answering these questions.
Thanks, Giles. So as Giles said, the project itself produced a framework for consultation that our participants felt the public would more easily engage with. The new framework is focused, or was focused, on two purposes and 4 principles. The purposes are a democratic one, enabling stakeholder contributions and accountability, and an epistemic one, developing knowledge that can underpin policy. And the principles are being inclusive, well-informed, equitable, and accountable. And in the remainder of this talk, we'll just focus on the principle of being inclusive for reasons of time, but we can talk about the other principles in the Q&A and talk about how they might foster public participation if people are interested. So the principle of inclusion was widely recognised by our participants, and it was defined such that anyone affected by the policy is by definition a stakeholder and should be included in consultations. And inclusivity is the type of principle that Rainer Forster's argued is difficult to reasonably reject without someone denying someone else a right that they themselves enjoy. So, for example, while more powerful stakeholders with better access to consultations may not find that ensuring greater inclusivity for others is the most pressing of their priorities, it is still difficult for them to deny efforts to give others the access and accessibility that they themselves enjoy. So inclusion has 2 elements. First of all, access relates to ensuring that all stakeholders who have relevant knowledge about or are affected by a policy are able to access opportunities to participate in consultations. And this includes things like all relevant stakeholders knowing that consultations are taking place and being able to use the channels that are available for submissions or participation. Participatory parity is an idea we borrow from political theorist Nancy Fraser. And in our context, it's to do with stakeholders' capacity to participate. And in the world of copyright, this addresses the reality that some are more able to participate and more comfortable with consultations than others for a whole range of reasons, including financial resources, time availability, but also being able to speak the language of consultations, as Giles was saying, understanding the issues at hand, being used to the environment, being used to the jargon, and feeling like your input is valued. And the idea seeks to counter the differences in material resource and social and cultural capital that characterize this current context for copyright. Now, as we've noted, participants recognised that inclusion was not achieved fully, and that in particular, the public voice, the citizen, the consumer, is underrepresented in copyright consultations. And this lack of participation really matters because it has implications for the legitimacy and effectiveness of the outcomes that result from the copyright consultation process. In turn, this means that copyright policy is constantly contested, it's regarded with suspicion, and the polarised positions of rights holders and civil society actors persist. Arguably, the public are the ones that lose out. They are caught in the middle, producing, creating artifacts, uploading videos and images, songs and mashups, but unclear about the rules, regulations, and risks that govern their activity. So how can the public voice be included more effectively in copyright consultations? Well, of course, there is no simple answer to that question. I'm sure you wouldn't want one. But it does start with thinking about consultations differently. And we stress the need to think about consultations in 2 different ways. To think about them first as a complex ongoing process and a system of interconnected methods. And second, to think about them from a stakeholder-centric perspective. And that means thinking about how the stakeholder experiences consultation rather than how the institution thinks a good consultation should be designed. Now, from a systemic perspective, this means that we need to think about how different methods can be combined to arrive at a good consultation process. So one that is inclusive, informed, equitable, and accountable to stakeholders in line with the framework that our stakeholders in the project produced. This doesn't mean that every method needs to meet all these criteria to a high standard. It means that combinations of methods are chosen to maximize the 4 principles across the whole consultation process. And in this sense, the principles act as regulatory ideals in the way that Mansfield has described, and not absolute standards. But specifically in relation to the absence of public voice, what methods might be used to address this? Well, we propose 3 different areas of activity that we hope will prompt some discussion. First of all, we need more independent research about the impact of copyright policy on publics, about how they perceive policy and its implementation, what they think is legitimate, and what could change. This kind of information can feed into consultations as vital background research that makes the public voice visible from the very beginning and can act as a reference point for consultation designers. We also need more independent research about how the public view consultations themselves more broadly. Where would they like to be included in relation to particular issues? What kinds of questions do they want to answer? Involving them at appropriate points with appropriate questions is crucial to avoid wasting their time, their intellectual effort, and to shore up their support for democracy. And we think that quantitative research as well as qualitative research is crucial in these cases. Second, we need to do a better job of listening to existing public deliberation in the public sphere. And we can do this through a number of different ways. First of all, for example, using social media, following what people are saying and taking it seriously, albeit in the context of technology and its underlying algorithmic structures, which we know can be problematic. We can engage civil society organizations and NGOs more frequently, both formally and informally, and reach out to their members as well as their leaders. We can reach out to other intermediaries as well, such as online influencers, to start or develop debates and to reach audiences that might not otherwise engage. And finally, we think it's important to stage new deliberative opportunities for the public through mini-publics such as the Citizens' Assembly technique or town halls. These events give publics an opportunity to reflect in a more sustained way with adequate information and support for their participation on topics like copyright. They could be held regularly, but they don't always have to be linked to a specific consultation. So some people in our workshop suggested that these things should happen perhaps once a year in relation to copyright so that the public could be kept up to date and consultation leaders could be kept in tune with public opinion as it slowly changed or remained the same. And these kinds of events can also deal with broader questions of principle and not only policy detail. So, for example, the values that should underpin or guide policy decision-making in the ways that we saw emerged through the 2016 event that we held. I just want to conclude with a word of caution, a few words of caution perhaps. Both of our projects were small, and it's relatively easy to construct a deliberative approach when one is dealing with a small and relatively localized set of stakeholders. How to scale public participation and deliberation up to bigger arenas and even international debates is much more challenging. And we've seen a fantastic example of this, so to speak, in the Copyright Directive, the European Copyright Directive law as it was debated and then eventually passed, and indeed in the subsequent stakeholder dialogues that took place over the last 18 months and were themselves very fraught, even though they were intended as a deliberative dialogic exercise. We also recognise that the political economic landscape of copyright creates barriers to change. Some of the things we're suggesting are designed to address its polarised nature by encouraging better dialogue between stakeholders. But positions polarise for a reason, And as we know, it's very difficult to persuade organisations and industries to compromise on what they see as hard-won territory. Nonetheless, and as the implementation resource illustrates, there are many different ways to engage the public in these copyright consultations. And in some cases, some of the approaches that we're advocating have started to emerge in some countries, and Ula may want to enlighten us on some of those in the subsequent discussion. But these approaches show that this kind of authentic public engagement is possible. It can be timely, it can be open and transparent, and it can be incorporated into policy decision-making. And this brings us to our final point. Public involvement in copyright cannot be a sticking plaster placed over a deeper democratic wound. The desire to improve consultations and to make them more inclusive has to stem from a desire to better realise their democratic and epistemic purposes. It is an ethical and moral choice as much as a practical and pragmatic one. And if that's the starting point, then public engagement has to be considered carefully. It has to be timely and relevant and consequential, and it has to be visible to decision makers and carry as much weight as any corporate, civic or political voice. These basic starting points are harder to achieve than might first be thought, and we realise that. But if copyright consultations are to genuinely include and accommodate the public voice, then they are indispensable.
Thank you very much. Thank you very much, Lee and Giles. These are, important questions. They go to the heart of policy making in all fields, but in copyright they're particularly pertinent. The question who has a stake is fairly new. 30 years ago, it probably wouldn't have been raised as an issue. So the issue has got a stake in copyright policy. What are the hurdles to participation? What are acceptable norms for deliberation? What are the techniques you can use to be more inclusive? All these are really important questions, and if they work for copyright law, they will work in many other fields as well. So what we thought we would do now is to give 3 people who had an involvement not as researchers, even though they are, some of them, researchers, but as policy participants or reviewers, to give us a view from the other side in some sense. So an understanding how does consultation and policy formation happen in practice? How does it feel on the other side if you try to run a process of this kind? And nobody better to speak about this than Professor Ian Hargreaves. And in the good old British tradition, often for these independent reviews, people are appointed who have no expertise or expert view on the particular field they are reviewing. So they come there with a fresh eye, and this can produce surprising results. So Ian, I would like to give you as much time as you would like to have. Quite a few of the audience are probably here because they want to hear from somebody they've read a lot about. Ian Hargreaves.
Thank you, Martin. And I just want to begin by saying that I think that the argument that Lee and Giles put forward and the work that they've done is pretty much beyond contest. It's not, you can't argue with the principles. You can acknowledge, indeed the researchers acknowledge that there are a lot of practical difficulties in getting a sufficiently well-informed and well organized and properly listened to and properly respected public element into the consultation. A question that occurred to me hearing the summary that we've just had of it is the extent to which they feel that they know of relevantly similar areas of where public consultation isn't as good as it might be, and this work about public consultation in a properly research propelled manner is not something that I know about. But it seemed to me it would be quite useful to ask the question, could the world of copyright consultation and its potential learn specifically from another area of contested points of view? No doubt it would be difficult to find anything that is close to identical, but there probably is quite a lot that has got a lot in common with this in other areas. But looking in the rear view mirror, going back now the best part of 10 years to the way that the exercise that I led took place, nobody will be surprised to know that there wasn't a properly organized and structured public consultation involved in that work. But there was a very strong sense of frustration and urgency that was not the case. And the substitutes for it had to be found, not least because the timeline given to the debate, I think it was put at 6 months in the shortly following the first phone call, and assembling a panel of experts in the case of the review that I did. That was essential because I wasn't an expert. I was somebody who had important, relevant contextual knowledge, but I'm not a lawyer, and I'm not somebody who brought that kind of background. But I am actually really by training, instinct, and probably until I die, a journalist. And so I very much felt that we needed to dig in other places. And so, of course, there are other ways that you do it that are not as scientific as you propose. And that involves making sure that you get into careful and meaningful conversation with people who are not part of the commercial or other types of organized lobbying, but who do, for one reason or another, have strong and often very, very well-informed views. But that was all done informally. I mean, we in the review that sometimes is referred to by slapping my surname on it, we tried very hard with all of that. How did we do it? We looked for people and organizations that whose voices, although often dim and distant to us at the outset, could be found, and you could get conversation with them. But it was more like journalism than carefully constructed and systematic academic research. So I didn't feel that we had no idea. We were flying blind about the public and what it thought. But it is absolutely fair to say that it was not scientifically established. in the way that you propose. So that's a roundabout way of simply saying that I respect and value the work that you and others are doing in this territory, and I think it's important. The politics, however, is something which, no matter how good your public consultation system is, no matter how transparent, no matter how well resourced, no matter how much time and effort is put into it, will, of course, be massively affected by the political context in which the research is being done. And if I look back now to the review that we put together, the world has been turned upside down again by the British Brexit story, and from the point of view of how all of that is going to work in the current EU procedure for moving the law forward, it's clearly very complicated, and indeed so complicated that you would hesitate to be confident that you could get people who may well have a personal insight into, even a stake in some copyright question that concerns them personally. You'd struggle to make the connection between the European legal and political process, which is still in train, and I'm not sure. I'd give it a go, but I wouldn't like to have to write an essay that was going to be marked by you guys on that subject. I'd have to do quite a lot of reading up to do that. It is very, very complicated, and yet it's not surprising to me that when you take the trouble to talk to people in an open and respectful and inquiring manner, that you find they get quite excited because these are also subjects that there are generational differences, but the subject of copyright is something which people, I think, do understand in its basics, and so I think it's also true that that the review that we produced was not ignorant about what was going on in the public conversation, but we had to report it in the way that bystanders and professional bystanders like journalists and people who do research but are not specialists in this area, it was possible to have a sense of what was going on in the mind of the public, but you couldn't rely on it as evidence because there wasn't the quality of work there to do that. And that's the thing that's missing. And I very much hope that whenever we get to the next stage of this, we see something more developed. I think I'm happy to leave it there, Martin, unless
no, it gives a flavor.
There is there may be an opportunity for us to trade questions with each other as we venture on in this.
Yeah, no, I think it's very interesting that there was in the process of an independent review there you take evidence, you take submissions there but the techniques of inclusive deliberation are obviously not spelled out at this stage. And I think you mentioned to me that you did pizza lunches in or after work lunches in after work pizzas in Shoreditch to reach groups who would otherwise not be part of the process. So deliberation can happen in unconventional settings. So Aline, she mentioned to me that the Hargreaves review actually reached Brazil and played a part in how policy was considered at that time. And so I would like to give Aline Ramina a few minutes to as a from a perspective of a civil servant, how did it feel to run the consultations in Brazil on copyright? Aline.
Thank you. First, I would like to congratulate Dr. Etters and Dr. Moss for their presentation, for their study. I think it's quite nice, important to have this kind of study available for policymakers in general. And from my previous experience, I know how challenging it is to organize and this kind of public consultations to be inclusive, well-informed, and transparent. Most problems that they addressed in their research, that I had the opportunity to read the paper regarding public consultations in copyright, are true. It's something that we know working, and we can actually detect these problems working with copyright. For example, the uneven access, especially the participatory disparity. I think, for example, for Brazil's public consultation on the reform of Brazil's copyright law last year, we received, I don't know, 250 contributions around that. And for like the general public that are not like related to the academy or some civil society groups, I can say that probably we receive it from individual participants less than 10 contributions, something like that. So I think that's a real problem. But as Dr. Edwards said, it's not an easy solution. And I'm not even talking about the final part of the decision-making process, because that's even more complex and involve political decisions and arrangements that in most cases are not even in the hands of those like me who are responsible for conducting the public consultations. But there are some structural, as you said, problems that are complicated to solve, but there's certainly a lot of room for improvement. But one thing that I found quite interesting that you said in your study, but you said that you conducted the events in 2016. So I'm not sure that perhaps that changed it, because I was talking to Professor Martin about that. One of the things that I thought it was quite interesting in relation to copyright consultations, comparing the one that we conducted last year for the reform of Brazil's copyright law and one for the implementation of the Marrakesh Treaty this year, it was the effect of the pandemic and the use of the digital tools that we have today. Because I was mentioned that I was talking with my colleagues that one thing that I consider that perhaps we can consider positive about the pandemic was how we have learned, we were obliged to learn to use some digital tools like Zoom now and others to organize webinars and online meetings. Because you talk in your study about face-to-face meetings and the importance of that, but working from the government and from the government perspective, I can say that for us, it's sometimes expensive. They demand a great amount of time and people to work and to organize this kind of events. And I don't know about the UK structure or the other European countries, but we usually have limited financial and human resources to work, to work with regulation and to work with public consultations. So this is quite challenging. And what I realized, for example, in Brazil last year, the government approved a decree that allowed the governmental bodies to pay for travel expense for third parties to participate in meetings, in other events organized by the government, only when video conference is not possible. So this is quite a bureaucratic process to get authorization. So they kind of limited much more the participation of other people in this kind of events.
Thank you. I think we give Lee and Giles an opportunity to respond once Martin Senfleden had his initial opportunity. So next in line is Martin Senfleden, exemplary at the interface between academia and policy, participated in several initiatives and is an advisor to the Netherlands government. So Martin Senfleden, would you like to take the virtual floor?
Yeah, thank you so much. Well, first of all, congratulations, Lee and Giles. I think this is very important work. And personally, I'm very happy that you put a focus on the situation in copyright law. When we look at the debate going on in copyright law, I think it's fair to say there are several figureheads in the copyright debate traditionally. One is, of course, the individual creator who really does the work. And in these policy debates, as you mentioned it, we have well-organized lobby groups like the creative industries, and the creative industries keep telling in these debates, I've heard this several times in a Dutch context myself, what creators actually want. And they say creators want more protection, but when you really have discussions with creators, then you may find out that this is not necessarily what they always want. They also want broad distribution of their work and so on. And the same, I think, we nowadays see with the individual users, which are actually the citizens, the everyday people, who are now the figurehead for lots of the content platform industry, saying what is going on here is about the users and what the users actually want. So initiatives to broaden the debate and bring in the view of users is very important. I have a couple of slides just to illustrate this a bit. I thought this is a good opportunity to show you a bit what you can unleash. I mean, what the final result can be in the framework of the copyright debate. We had in particular a very strong reaction in Germany, German citizens on the streets against the so-called upload filters, and you get a bit of a flavor here. This first illustration is, I translated, it's about things that people don't want, filter coffee, filter cigarettes, but also upload filters. And it also says that the government should take care of filtering diesel motors and not so much filtering the internet. I mean, this is rhetoric, but you also see that there have been much more nuanced statement saying upload filters can't identify satire. This is a very valid point. Upload filters, in fact, as technological measures, cannot make a distinction between piracy and parody. So these kind of slogans show very clearly that citizens can actually understand what is at stake. And in the current debate on implementation, you will see this on the overview webpage. Very useful resource, Ula. Congratulations on this, and also create on this webpage. The government reaction in Germany to the implementation is a very special one. I mean, the German Ministry of Justice officially declared that in the implementation of the new EU legislation, they would do whatever they can to avoid upload filters. And so I think this illustrates really nicely how important it can be to really hear the voice of the crowd, of the people. And then the question is, of course, well, I myself, I'm from the academic world. I have been involved in academic initiatives to really put the issues clearly on the table, as has, well, the same goes for Martin from CREATE, also our colleagues from the Max Planck Institute in Munich, and so on. So there are several academic institutions that contribute regularly to these debates. So what is our contribution then? Well, as I see it, there's an important role in translating the technicalities of the draft texts and so on into something which people really can understand. You may now say perhaps academics are not the most obvious choice for doing this, but I think we are getting better at it. Why am I saying this? As I said, there have been several initiatives that led to really quite promising results in really presenting in a nutshell what the new legislation on the table for debate is really saying. So again, in the case of the copyright reform, when you look at the text as such, it doesn't even mention the word filtering. It doesn't mention the word content censorship. So somebody has to inform the public that this is actually what is at stake. Somebody has to say, listen, there is a climate change going on here. We had a European policymaker who trusted you in the past, like you can upload what you want and we do the filtering afterwards when objections come in from right holders, the notice and take down system. And this is going to change. The policymaker will no longer trust you. Everybody is suspicious. Whatever you upload is something that will be checked and filtered if there is something that does not seem in full conformity with copyright protection. So these kind of messages, or even simpler messages like what is at stake here is a user freedom. It's not all about remuneration of, well, the industry. Question how the money ends up at individual creators is a different question. It's also about user freedoms. It's about your freedom to express yourself in the online environment. These kind of messages really come from the academic circles. At least this is our experience, I think, in the copyright debate. And I must say, as academics, I think we cannot always hope to really reach the people on the street. Of course, you can translate this also in newspaper articles and something doing more work that is closer to journalistic work. But I must say what was encouraging and worked pretty well is reaching the representatives of the public in the parliament. We must not forget about this. So if you don't reach the European Commission, or perhaps you are too late for that because the policy-making process is already at a stage where the proposals have been made and there's only room for small changes, you can always reach out to the parliament. And I must say, in the copyright debate, the parliament really added lots and lots of important nuances in the end, by saying things like whatever you introduce as copyright legislation, certain important user freedoms like freedom to quote, freedom to parody, freedom to make pastiches and mashups, these kind of things. This is something we now have in the text. And I'm not so sure if this would have happened without this function of putting the things clearly on the table and explaining what is between the lines of the legal, doctrinal technicalities of the text. So I think this is where the academic world can contribute quite a lot to this debate going on. Thanks so much.
Thank you, Martin. So I would like to give Lee and Giles an opportunity to respond to what you've heard just now, not too long, and then we move to the questions from the audience.
Thanks, Martin. Thanks, everyone. Those are really, really interesting comments and kind of add to the richness of the picture, really, that we're painting here about, you know, how consultations about copyright unfold, what their limitations are, but also what the possibilities are for doing things differently and for creating a much more inclusive and perhaps equitable process. Ian, you mentioned the possibility that other policy areas there might be some kind of mutual exchange of learning between copyright and other policy areas. And I'm actually going to hand over to Giles to see if he would like to make an initial comment on that, because Giles is actually the media policy specialist between us. And so Giles, I don't know if you want to just respond to that first, and then perhaps I can talk to Aline.
Well, I think certainly I think we mentioned this in the talk in terms of the literature on media policy making. Some of the things that we encountered in the copyright debate are very much reflected there as well. So some of those similar challenges. I think that perhaps the copyright debate seems particularly stark, some of the conflicts of interest, but I think that these themes are common in some of the media policy literature as well. I'm not aware of as much research talking about how to actually improve the copyright consultation in quite the impact-oriented way that we did in the research, but certainly the kind of challenges that we've talked about are pretty common across areas.
I think one of the things to pick up on, and Aline and Martin, you mentioned it as well, is this idea of the context, the political context for consultation. And of course, while in copyright that takes a particular hue, the political context is the political context for any consultation, isn't it? And we've done some recent work on public media, public service broadcasting rather. And what's interesting there is that even though the organisation that we're working with does a lot of consultation and is very kind of plugged into the public, nonetheless, there are still gaps in the way that the public are listened to and the way that the public are incorporated. And I think this goes back to your point, Ian, about, the fact that there might be an idea that the public are important. And it sounds like there might not even have been that with the consultation that you led, but certainly you recognise that. But there wasn't really a formalised way of bringing that into the process and accounting for it. And one of the things that you mentioned was the need to somehow have evidence that can be submitted with everything else, that can be accounted for with everything else. So alongside the big studies that the big corporates might do or other organisations might be able to provide. And the evidence also came up as a big theme where, one of the big problems was that quantitative evidence is kind of easy to understand, it's easy to assess, and it's easy to incorporate because we all love numbers and we understand what they mean. Qualitative evidence is more problematic, and a lot of the public input tends to be qualitative. It tends to be discussions at things like deliberative events and town hall meetings, etc., if it happens at all. And so that was one of the reasons why we thought that quantitative evidence was really important to include there as well. Aline, you were talking about the online, offline changes through the current pandemic, and I think we would have to agree there, really, Giles, wouldn't we, in the sense that we've just done, in relation to this public service media debate, we've just done an online deliberative event, and it worked really well. I would really like to see some comparative work to see what the relative strength of online and offline is, because it just worked well for us, but we haven't really got a baseline to compare it against, apart from the fact that we did a face-to-face one earlier in the year, and it was different, but it was also good. So I think some research around that, given that, as you say, online is often cheaper, it's much more feasible for countries with limited resources, which is basically all countries now that we have a pandemic and we have to pay for it. and there's, there are opportunities there as well. There are ways that you can bring people together from all over the country in the same space, which you could never do, no matter how rich you are in a face-to-face context. So I think that's we would agree with you there, and that there are more opportunities perhaps to explore these avenues in the context of this kind of work than there might have been previously, because we're all used to it now. Giles, I'm going to hand over to you to see if you want to respond to Martin.
Yeah, thank you. Well, could I just respond more generally first? Well, thanks to the discussants. It's good to hear that our research has resonated with you, as people have got such a wealth of experience on the other side, as Martin was saying. And you, across the three of you, mentioned a range of different methods for engaging with the public, or engaging with consultations. Ian mentions these careful conversations with those outside of organised lobbying. Alina mentions obviously the online discussions and engagement, and as Lee says, that is something we've been experimenting with more recently. And Martin showed us the public protests in Germany, and also discussed academic contributions to consultations. And I think that one of the things we tried to stress with this systems perspective is that we think that all of these different methods have value, and all methods have weaknesses. They all have strengths as well as limitations. And the really challenging thing is to think at a kind of a systems level, thinking about all these different methods that might go into informing a consultation, how they can complement one another, and how we can balance them in order to achieve the principles and purposes we want to achieve with consultation. And it's interesting you mentioning the online. One of the principles that didn't make it actually into our framework, which we did talk about, was cost effectiveness, and obviously that could be or affordability could be a crucial consideration. I also just wanted to pick up, I think, another theme that was coming up, which is about, and it's related there to what Alina was saying about affordability of these principles, whether they fall when they come up against reality, really. And we're aware that these principles are kind of ideal principles, and as Lee was explaining, we think of them as regulative ideals. So they're things that are difficult to achieve in practice, may be unachievable in their full form, but they're not an all or nothing thing. They're things that you can realize to a lesser or greater extent. And what we should aim to do is obviously try and make improvements in those areas. But I think that making improvements, and this is, I think, one of the other things we've really wanted to stress, involves us talking about this and reflecting on these principles and how we design consultations. I think one of the really striking things for me when we did the research, the more recent research, is talking to people who regularly participate in consultations, saying there were aspects of the process they didn't really understand, or they didn't have an opportunity to give feedback or talk about consultations in this way before, which is interesting. It was really, sort of confirmed to us the importance of having a bit of consultation about consultation, if you like, which is what we hope we sort of started with the project. Thank you.
No, I think that may be one of the most important contributions, also from today's event, really, to reflecting about how we do it, how does it happen. We all do it in some ways, but how do we do it? And forcing us to look in the mirror is always a challenge and not easy. So we're moving now to question and answers. We encouraged the IP Student Society at the University of Glasgow to read your study and also the context around it, and offer some questions. And I think they are fascinating questions, and I've had them uploaded by Carrie on behalf of the IP Society, and I would like to pass some of them on now and to see how we go. So the first one here from Lena King is: did you find that public perceptions of copyright were influenced? That I go for the next one. Did you during the course of your research into public engagement, did you come across any commonly held copyright misconceptions among the participants? Okay, so that's obviously a difficult question for you, Lee and Giles. You're not copyright lawyers, and you're not there in your constructing deliberative exercises to assess whether people understand or don't understand. But you took great care, I think, when you started your deliberations to brief the people from the bus. And you had very interesting techniques how to do that. So to increase the level of competence before you start engaging with normative aspects. But still, do you have a particular take? Is there any particular aspect where the public really is on the wrong horse from the beginning? First to you, Lee and Giles, and then we can ask anybody on the panel.
Maybe I'll start and then Giles can come in. I mean, I think we weren't looking for misunderstandings, and as you say, we're not copyright experts, and so, or legal experts rather, so we might have missed some. What we did know was that they wouldn't be completely clued up about copyright and in all its detail. And so I suppose, and what became clear was that there was a lot of uncertainty rather than misunderstanding. So there were some, kind of general beliefs, but often based around personal experience. And where people became unsure or where there was more clarity was needed, we did have experts on hand in the first event of whom they could ask questions to get some clarification. We didn't really want them to discuss the detailed specifics of copyright law. I think that probably if that came up, it would have been fine, but our interest was in allowing them to talk about copyright in a way that was meaningful for them, which didn't necessarily mean they had to name articles or understand specific terms, but those did then become explained as they started to work out how their experience of copyright was translated in and through policy, and therefore how policy was affecting their lives in the first event, certainly. In the second event was slightly different because we had a mixed group of people around the table, a mixture of the public and stakeholders who were very well versed in copyright. And Martin's right, we prepped people quite a lot, both for the context, but they already did have this weekend of discussion about copyright. So there was some knowledge there as well. But again, the questions that we pitched there were at a relatively general level, who should participate in consultations about copyright, how and why. And that allows everybody to at least start the conversation on the same page and then go into more detail based on their individual experiences and knowledge. And so again, the idea of misunderstandings or misconception, I think, was less important. There.
Anybody else from the panel would like to
Giles
offer something?
I think you've answered it from our perspective,
Yeah,
so I'll let other people.
Okay, we'll just leave it at that. I've given one question from Gabriele Cifarelli to Ian Hargreaves here, because your review also had a focus on digital literacy as one of the aims as well, isn't it? Innovation involves that the society is able to engage creatively with digital technology. So the question here is really on these lines. So Gabriele asked, do you think that today the public is more interested in copyright since the digital environment enables anybody to create something, such a TikTok video and meme? And what kind of sensibilization does this more inventive public have? So if everybody is creative, it does that from the perspective where you reviewed copyright law. Did that make a difference? Did that affect how you looked at this area?
Well, the underlying or overarching, argument in our review, which was entitled "Digital Opportunity," was that there was a danger that if we did not sort out how we think about copyright in the digital age, that we would do enormous self-harm to our economy and to the, if you like, to the creative industries and the creative economy. And I think that thesis absolutely has stood the test of time. And the way this question is put is this going to happen to an even greater extent as young people involve themselves in digital forms of creativity to an ever greater extent. And I think that the argument here is still very, very powerful that is so. And I think that if that we have seen in public protest in different parts of Europe, we saw some reference to it in some of the pictures that were shown. That kind of resistance to intellectual property law, which attacks freedom of expression, or may arguably as a side effect affects freedom of expression. I think that that engine is still running. I think that there is a very serious danger that Europe still does not understand the extent to which this is important in terms of its economic future. But it's also true that the internet has generated sources of concern and alarm. Simply note the conversation that goes on in politics, and not only among professional politicians, about social media and their effect upon the reliability of what you can discover through digital media. So it's not a one-way street, the moral and democratic argument. The time that we're in now is a time when we are being tested for the depth of commitment that we can show and the skills that we will apply to the regulation of platforms. I mean, it's obviously a very large subject in its own right, but I think that to the question, are young people who are themselves creatively active on the internet to an extent that older generations were not and are not, what will that make them think about copyright? Well, it might actually encourage some of them to think the way that commercial creative organizations think about copyright, that if I've put work in there, I'm entitled to expect a return from that. But the underlying thing here is that these are questions that are of such far-reaching importance in our societies that we cannot afford to let them be arbitrated in a narrow and segmented manner. We have to recognize the importance of these issues at the highest degree in which we think about truthfulness in media and freedom of expression and all of those enormously important subjects. This is the debate that we have been involved in this evening is a debate which is going to get more and more important, not the opposite.
Thank you. So we're rapidly running out of time. I want to give Ulla a brief opportunity to respond to a question from Sam Dillon. Did you find that public perceptions of copyright were influenced by any legal system in particular, or was it more from popular culture? So,
I must say that when it comes to the public perception, it's not something that I'm monitoring as a part of the implementation resource, because we are very often talking about the public perception, thinking about what is public writing in English or any other language that is accessible for us. And we need to remember that the perception, the public discussion that is happening in the member states during the implementation process is largely happening in the native language of this country. And it's 24 different countries that languages that are official. And on top of that, we have languages that are, of course, other languages used in those discussions. So I would not really dare to answer this question in the context of national implementation processes that I'm monitoring. But in here, maybe a little bit of remark about how the legal system of particular member states influences how actually consultations are happening. And I think this is to a high degree, actually. So in a way that the administration is being organized, so whether we have implementation and consultation processes happening through ministries, or whether they're, specialist groups that we have, or the IPOs, how transparent those consultations are. And also, it's quite important when we are talking about the public discussions, and here we are quite interested in about public movement, and yet in Germany there are protests and so on. But we need to remember that the level of representation of public in different member states is very different. The level of representation of creative sectors in certain member states is also very different. So the way that the public consultations are happening in those member states does take under considerations the specificity of legal system or the administration of a given country, and also how the public and the creative sector is represented. So I wouldn't say it's pop culture or public culture in this way, but as a consultation process, and this is structured, and it's something that you can also see in our resource, there are those differences influenced by those things. I don't know if it answers the questions, but I wouldn't dare to answer the question not knowing those discussions.
thank you. So I would like to give one more round to everybody and basically group a few questions together, which all look at forward, going forward, how could we meaningfully improve the process? So there are a number of questions which look at, is there some kind of mandate that could be created? Could there be something like consumer focus again in the UK, a representative for the public or for the consumer? Should there be citizen panels? Should there be something like a jury service where citizens are drawn into a process? They have to participate. So there a whole range of questions which look at how can we make the participation of the public meaningful and mandatory, and with suggestions in there. So if you have any views, what might be possible there, that and what you would support, that would be very interesting. I mean, you all can read the questions, and I encourage you to do that. There is also a very interesting one from Chris Morrison on the history of consultations. So again, the UK has this tradition of reviews, which goes back to the 19th century, where committees are formed when major legal reforms are envisaged, and they took evidence in a particular manner, which is still very interesting now. If you investigate how the policy came about, you can actually see how the evidence was collected. So again, an interesting tradition, but I don't think we can probably in this context answer that meaningfully. But I think I would like to go the round, and so looking ahead, how can we ensure that there's a meaningful participation of the public in the next copyright reform, which certainly will come. I start with Martin Senfleden.
Yeah, I'm not sure I share your optimism. I think the copyright reform we just had at EU level is something that will stay for quite a while. But of course, in the UK, you may have a fresh debate about this and find better solutions, hopefully. I mean, with regard to getting the public involved, I think it is a process that is following more or less automatically, because as we have already said in the discussion, this is dear to people's hearts nowadays. We have this whole process of user emancipation. The internet makes everybody a contributor to the debate. So there is a loss of control at the, let's say, organized interests of the cultural industries and how they made the selection process in the past. So I think to some extent I'm optimistic that this will happen more or less automatically, because people really hit the streets in order to make their voice known. What I would like to see is a more positive attitude, more invitations of getting involved. At the moment, I think the impression that is given is still that these debates are taking place behind closed doors, and you don't really know what avenue you have available for getting a say in the whole process. So a bit more transparency could help, but in general, I'm optimistic that this will happen more or less automatically. Thank you.
Okay, Aline?
Sorry, I'll be very quickly. Well, as I said before, I think, as talking as someone from the governmental perspective, although I'm not there now, but I think the digital technology, I think it can help the government, from the government perspective, to try to engage more users and the general public to participate in public consultations and to be part of the process more directly. Also, one of the things that I saw in the study that I think it was quite important is the language. And I think it's not only one problem that I saw in Brazil. I actually saw some documents from the European Union and also from the US about how they conduct their public consultations. And we can see sometimes that the language is not very accessible indeed. So maybe something that we can work on that. And I think maybe it could help to make more understandable, and people can actually feel more comfortable in participating in this kind of public consultation. But I think that would be my opinion about that.
Okay, Ian, briefly, and then last word going to Lee and Giles.
Thank you, Martin. I'm on the side of the optimists that this is a problem which sits deeply, knee-deep in the technology, and the technology will be used and will afford usage, which makes it possible and enables it to happen that people will be able to express concerns that are genuine and widely and deeply felt. There's a lot to worry about the internet, but there's a lot more still to rejoice in its existence and its potential for the future.
Thank you. Lee and Giles, the last word.
Giles, do you want to?
Yeah, I'm happy to go. Yeah, so I would echo some of what's been said in terms of clear and accessible language. As we mentioned, as Lee mentioned in the slide in the presentations, I think the value of independent research into the public and the public's views is really important. The promotion of consultations was something that's really emphasized as well in our research, the need for them to be more widely promoted, and obviously media has an important role to play there. And I think that we'd argue as well for the importance of some kind of mini public, whether that's you saying a citizens panel or a citizens assembly, where you're getting the public's input, but in a way in which they've had an opportunity to really reflect on the issue in some depth in an informed way. So similar to what we did in the our first piece of research, but perhaps going even further, one of the things we weren't really able to do is go to the step of detailed recommendations. I mean, that would take a longer process. So it would be fantastic to see something like that as one part of a broader consultation process.
I think just to echo Giles's point, I think the point that Chris makes in his question really about embedding things in the political process is also, you know, goes along with some of those proposals that everybody else has made. It is, you know, that political context is so important because the political will for change is really critical, no matter how much we respect people on the street and the user voice and how much scope they have to speak now. So embedding any change in the context of a much stronger political will to recognise and listen to the public, and to be prepared to do things really basic like translating language through the use of academic input, or, you know, changing the way that consultations about copyright are talked about so that people actually understand what's going on and feel that they're valued in that process. Those are also some kind of requirements, I think, from the public side to make sure that things happen. I'm probably slightly less optimistic than some, but more optimistic than others.
Well, I think we can end on this knife edge. Let me thank you on behalf of University of Glasgow of Create for an excellent lecture and a really interesting discussion, which I think we could continue for quite a while. Let's do some virtual clapping. I think it's appropriate. And I can put it on the gallery. Thank you. Thank you very much.
Thanks very much.